Good evening, welcome to my YouTube channel. My name is David Okon. Today we are going to talk about work in the United Kingdom. We are going to talk particularly in terms of employment contracts. If you watched my video before and watching this again today, then you will realize we took a break to celebrate summer in the United Kingdom. Summer is a very special season in the United Kingdom and in similar regions of the world. So if you watch this video, watch the rest of the video on summer in the United Kingdom, and also watch the videos on work in the United Kingdom. Work is very important because it is the source of income in the UK, the primary source of income in the United Kingdom. It is comparable to financial support provided by the UK government to help people on low income and also people who work for a living. Benefit is not a grant; it can be a loan. It can either be a grant or a loan or some other form of finance or some other form of support. So we are today going back to looking at work. We are in particular going to pay attention on employment contract. We spoke on employment in the United Kingdom in different ways. If you live in the UK, pay close attention because employment is extremely important for those who work for a living during at the age of work, but also some pensioners, people who are pensionable age, who are on pension may be interested in doing work, especially employment. Employment is the primary component of work in the United Kingdom, but also a self-employment, which we also touch on going forward in terms of employment contract. We're going to explore different elements. So stay tuned. Thanks so much, everyone who have been supporting this channel. If you haven't subscribed before, subscribe to this channel to support it, and also leave a comment, click like, click notification bell, and share while watching with family and friends. Thank you so much. So we are going to define employment contract. Employment contract, a contract or a contract of employment is an agreement between an employer and a worker. So it contains express terms, implied terms, and statutory terms. Statutory terms are sources from the contract. Implied is what you may or may not have been told directly. Express is what was actually stated either in writing or otherwise. Stay tuned, continue watching. Thank you so much. So, things to look at: finding out what to do if an employer changes the job description or terms and conditions of a job. This is a kind of issue of employment in terms of law, which may arise involving the relationship between employer and employee, and also you can also work out how long the service is, the service of employment, the length of an employees, the continuity of employment. You also look at statutory employment protection. Stay tuned, continue watching. So checking employment contract, we look at written statements. We look at other important information about an employee, what your employer has sent to you. These are information you would be able to check. And there are some verbal agreements, something written by the employer, which is verbally agreed. Implied terms, you check on your statutory rights. If you are in a probation period, you also look at that. Employment contract, also you all look at the breach of employment contract. So employment is a legal contract. It's a contract in your legal agreement with your employer. It includes things like what your job is about, and how you will do the work, and what your employer will pay as in salary. So your employer should be able to give you an employment contract document known as a written statement. Your written statement will include some of the terms of your employment contract, but there might be other terms as well. You can look at the terms of employment in your contract. You can check to see if they are in other information your employer sends, like an email or a job advert. Whether you verbally agree them with your employer, what the law might say, also the law also says you have a number of employment rights called statutory rights. You have these rights even if they are not mentioned in your contract. So we look at written statements in employment contract. So your employer has to give you a written statement, a statement of contract of the main terms of your employment contract. The employer should also give you written statement before you start work or on your first day of beginning employment, of commencing employment. So you might, the contract might also have employment contract as the title. So you are entitled to a written statement if you are an employee or a worker, including an agency worker. You might be an employee or a worker even if your contract says you are self-employed. You won't get a written statement if you run a business and you work for a client. If you are not sure if you are an employee or a worker, check your employment status. We have discussed in previous videos about employment status. If you comment below, stay tuned. Continue watching. So you look at how much and how often you will be paid, where you'll be working, the hours you have to work, how much holiday you will get, the rules about sick leave and sick pay. You can check the full details of what needs to be in the written statement on gov.uk. So also your employer hasn't given you, if your employer hasn't given you a written statement, ask them to send one for you to keep and to also make it available when you need it. So you're looking at employer. If your employer hasn't given them, if your employer hasn't given you a written statement of contract under a circumstance like such as that, where you haven't been given a written statement in this situation, what are you going to do? So you can only get compensation for not receiving a written statement if you successfully bring a different claim to the employment tribunal, for example, unfair dismissal. So you must have received the written statement before you started the employment tribunal claim. So these are some of the points you may need to consider when dealing with employment contract, and also any attending dispute resolution associated with these employment rights. So the employment tribunal will make the employer pay your employer paying you compensation of 2 weeks pay or 4 weeks pay if there's a good reason to make that payment to be available. So there is a maximum amount for a week's pay. It is the same as for unfair dismissal. So you can check the maximum rate for a week's pay as well. So look at other information which an employer must have sent to you, and so therefore there might be a contract. There might be contract terms that aren't in your written statement, but in the other documents. For example, the job advert for the role, and also letters or email are sent to you before you started work. Things like that. Anything your employer has asked you to sign, or an agreement between your employer and the trade union, and so if you don't have a copy of any document, ask your employer to send such documents to you. So you look at trade union agreement. If you are in a situation where your employer has an agreement with the trade union about contract terms, discount as terms of your employment contract. So even if you are only set out, if they are only set out in the trade union agreement, so there are national agreements about employment terms for some group of public sector staff, including state school teachers, national health service staff. These are public sectorial workers. So it is also worth checking documents like a staff handbook or your employer's policies. The information in these documents might be contract terms, or it might just be guidance. To talk to an advisor if you need to check if something is in one of these documents is a contract term. So you're looking at staff and books and policies. So it's complicated to work out what's a contract term and what's just a guideline. So if you are in a situation where you need to rely on something in a staff handbook, and therefore also your employer's policy, you can contact an expert advice team for specialist advice. So you can log in online to share the expert advice team a message. These are some of the guidelines. So if you verbally agree something with your employer, something you have agreed verbally can be a term of your contract, but it is difficult to prove it later. And therefore, if you make a verbal agreement with your employer, ask them to write it down, sign it, and send you a copy. And if your employer won't write such information down, send them an email saying what you agreed. This will make it easier to prove that you didn't make it up later. So we'll talk about proof. Let's talk of in terms of implied terms of contract. So some terms are in your situation, in your employment situation, which are also in the contract of employment, in your employment contract. They are there even if they are not written down or agreed. These are called implied terms. So you may be in a situation where your employment contract will always have implied terms, and that will mean you must have you must do what your employer tells you to do, as long as it's reasonable, and also you must use reasonable care and skill when doing your job. And you should also be in a situation where you doing your employer must take reasonable steps to keep each other safe, and also keep other employees safe. This is called having a duty of care. Leave a comment below, let me know what you think. So you will also, your employer must also pay you at least the national minimum wage, the national living wage, if you are entitled to this. If nothing is written down or agreed about an issue, the employment tribunal will sometimes decide there is an implied term in your situation of employment contract which fills the gap. You might do this because the term is needed to make the contract work. It is how things always work in that workplace. This is called a term based on custom and practice. And also, if you are in a situation where you need to rely on these types of terms, you can contact your expert advice team or specialist advisors for specialist advice. So you can log in online to share the expert advice team information, including messages. So you can check also for your statutory right. So statutory rights they depend on your situation, but they can include rights to get pay slips, to be paid at least the national minimum wage, national living wage, to take at least the minimum number of paid holiday days, and to take a maternity leave and other types of parental leave. You are also entitled to your statutory rights even if your employment contract says you aren't. For example, your contract can give you more than the minimum number of paid holiday days, but it can't give you less. So this is some of the difference between contract and also statutory information in terms of contract. So therefore, if you are in a probation period, you can also check what your contract says about your rights during the probation period. For example, you might say that your employer can dismiss you without using their full dismissal procedure. So your statutory rights aren't any different during your probation period. For example, your employer still needs to pay you at least the minimum number of paid holiday days. So you're looking at extending probation period. You would be in a situation where you could be in a situation where your employer can only will only be allowed to extend the probation period if the employment contract says your employer can. And your employment contract with a probation period usually say your employer can only extend it before the end of the period. If you are in a situation where your employer tries to extend the probation period when the contract doesn't let them, they are trying to change the terms of the employment contract. Check what your if you're in this situation, check if you can do what you can do if your employer tries to change your employment contract terms. So therefore, we are also looking at if your employer breaches your contract, and so you should start by talking to your employer about the problem. If they have made a mistake, they might be able to fix it. If that doesn't work, you can raise a grievance. You can also check what you can do if you have a problem, you have problems getting your pay. If your employer has done something that seriously breaches your contract, you might be also able to resign and make a claim to an employment tribunal. This is called constructive dismissal. Checking the rules, therefore, about constructive dismissal and also breaches of contract. If you are in a situation where your employer breaches your contract of employment, then you can usually take them to the employment tribunal or the civil courts. You can check this in this situation if you should bring your claim in the employment tribunal or the civil contract. Stay tuned. Thank you. Stay tuned. Continue watching. Let us now continue talking about work, employment, contract. Let us also look at changes in terms and conditions of employment. What you can do in such a situation. This is a voiceover, and it will be actually inserted into a prepared template. This prepared template is a reflection of summer times as we celebrated taking a break from talking about work in the United Kingdom. So I will also be using the template, but the content of the template will also be talking about work in the United Kingdom. There may or may not be direct relationship between the pictures, the videos, template, and the topic. But bear with me. I'm just doing it because although there might be some relationship between work and the video template, which actually portray nature, environment, the land, the trees, waters, birds in the river, blue skies. Life, there is always life in different aspects. But let us talk about employment. Let us talk about changing an employment contract. We will also look at how to deal with a problem about a change in terms and conditions of employment. We are going to also look in cuts in pay, cut in sick pay, cut in holiday pay. These are some of the situations you face as a worker in an employment situation or worker situation in the United Kingdom. And like I've already said previously, what happened in the UK is most likely to happen in another country because of globalization, cooperation within the global system, and also harmonization, where things in one country may be similar or the same in terms of law and policy. Stay tuned, continue watching. If you haven't subscribed this channel, continue, please continuing to watch, sharing with family and friends also. And also clicking notification bell and subscribing if you are new. If you have already subscribed, thank you so much. Thanks so much for your support. We are looking at cuts in fringe benefits or perks. We are looking at change in hours. We are also looking at change in place of work, changes in job duties. We are looking at qualifying periods for claiming unfair dismissal also. Stay tuned, continue watching. So let us look at when an employer changes employment contract. So when an employer changes an employee's contract in terms of job description, in terms of the job, for example, increasing or decreasing their hours to be worked or cutting pay, the employer is varying the contract of employment. So in theory, the contract of employment is like any other contract, and both parties must agree to a change for it to be effective. However, in most contracts, the two parties agreeing to the terms of the contract have equal bargaining power. With contract of employment, an employee does not have the bargaining power of the employer. This means that when an employer wants to change terms in an employee's contract, the employee's options are limited because they will want to keep the job. Some contracts allow the employer to vary some or all of the terms, and the employee will not then be able to reject the changes that are proposed. Leave a comment below, let me know your thoughts about employment contract is between an employer and an employee. So when advising or receiving advice, you look at contracts, you look at the situation involving the contract of the employer, of the employee, and the contract, how it has been changed, the way it has been changed in one way or the other. Then you first find out whether the employee want to keep the job. So if you're in a situation to check things out for yourself, for example, you determine whether or not you want to keep the job, or if you don't care about the work, you want to leave. So you have some options which could result in your dismissal. And although it may be possible to claim compensation for the loss of employment of the job, getting the job back is always difficult and frequently impossible. Stay tuned, continue watching. So let us look at the business which has been transferred from one employer to another. So you are in a situation where a business has been transferred, and you have been, or you have been, or you are employed in a business which has recently been had a change of ownership, and you don't use this pay. You are in this situation. You can work out what you would be able to do, or what you might not be able to do about the changes in the contract of employment, and you are also doing well to consider that special rules tend to apply. So you can actually do further consideration to look at your rights as an employee. when a business has had a change of ownership. So you look at what counts as the terms or condition of employment. The terms and condition of employment are anything that was agreed between the employer, the employee, and the employee, whether in writing, verbally, or by working a workplace practice. Stay tuned, continue watching. So these would normally include the following: pay, hours of work, holiday entitlements, sick leave, and sick pay entitlement, fringe benefits or perks, place of work, and the job duties and responsibility, maternity rights, redundancy rights, and so on and so forth. Stay tuned, continue watching. So you need to pay attention, close attention to this situation, and consider your options because they are fundamental in whether or stay tuned, continue watching. Let us look at variation terms in a contract of employment. So if you find yourself in a situation with a written contract, you can check to see if it includes a variation terms specific to the change being proposed. A variation term is one that allows an employer to change a term and condition without prior agreement from the employee. For example, it may say normal working hours are 40 hours per week, but this may be increased if this a circumstance call for it. So alternatively, the contract may say normal hours of work are 40 hours per week, but you may be required to work overtime at weekends, which will be paid at time and a quarter. Stay tuned. So the courts have decided that to be enforceable, a variation term must be specific. A general term in a contract allowing an employer to make alteration to the contract cannot be used except to make changes of a minor or non-fundamental nature. If you find yourself in a situation where your employer makes significant changes by relying on a term in a contract which allows unilateral changes to the contract, that you as an employee may be able to claim constructive or unfair dismissal, or otherwise constructive unfair dismissal. You can look more at constructive dismissal. If you watch this video, watch for the rest of the video, where I've mentioned a possible visit to Governor UK here in the United Kingdom. If you live in the United Kingdom, if you live outside the United Kingdom, consider this situation of employment in the United Kingdom in terms of contract, because it might or it might not be the same or similar to what happened in your country. So carrying on, even if a contract contains a variation term, if you are in such a situation, you may still be able to challenge the proposed changes. This is because the employer's ability to invoke a variation term may be limited by other implied terms or by the application of other contractual terms. It could also be the case that the term is indirectly discriminatory. Each case is decided individually, and if you all find yourself in such a situation and you wish to challenge a variation term in your contract, then you should be referred to a specialist employment advisor. Living current law is a situation involving employment law. Let us also look at the agreeing to or objecting to a change. So if the employer cannot make a change unilaterally, the employee must accept or be deemed to accept the change in the contract of employment. So you won't have to say, I accept, or you do not, or do they have to sign anything or put anything in writing. Just continuing to work and not objecting to the change will mean that the employee accepts the change. If you comment below, stay tuned, continue watching. So if an employee wishes to object to a change, they must take positive steps to do so. So they should make clear to the employer or employer's representative, such as a personnel manager or the employee's manager, that they object and say why they object. So preferably, they should do this in writing and keep a copy of the letter. They may also wish to raise a grievance. If they cannot continue indefinitely working under protest, So if you are in a situation, you will also have to consider what further action to take. You must consider taking legal action where appropriate, or resigning and claiming constructive unfair dismissal. This might be your option. So when we look at terms negotiated by trade unions, in such a situation, if you work for an organization in which a trade union has bargaining rights, you may not be able to stop a change in your contract by objecting to this state of affair. So you may look at bargaining rights, meaning that the employer recognizes a trade union as having rights to organize in the workplace and to negotiate on behalf of members of on member staff on behalf of members. So these negotiations result in collective agreements which frequently govern all employees' terms and conditions of employment in the workplace. For example, if a trade union agrees that the employees will give up a day's holiday in exchange for a pay rise, an employee who is covered by that agreement cannot object to it. Their contract will be changed automatically. It makes no difference whether the employee is a member of the trade union or not. If an employee is in a workplace covered by a collective agreement, any changes to the agreement will automatically be incorporated into the employee's contract of employment. You find yourself in a situation and you want to challenge a change to a term or condition made because of an agreement between the employer and the union. So you should be referred to a specialist employment advisor or solicitor who specializes in employment law. More about how to find a solicitor who specializes in employment law. So if you are in a situation where your employer is planning to make a substantial change to the contract of 20 or more employees, they must carry out a collective consultation first. Consultation must be with either representatives or a recognized trade union or employee representative. The employer must consult even if the contract changes won't lead to any redundancy. Stay tuned, continue watching. So look at the effect of a variation of contract if it fails. If an employer tries to vary a contract but the variation is not effective, then all the terms of the old contract continue to apply. None of the terms of the variation has effect. An employee can't pick and choose which part of the varied contract they wish to keep in their contract. Stay tuned, continue watching. Let us look at how to deal with a problem about a change in the terms and conditions of employment contract. So checking the contract. In such a situation, a client looking at variation or making consideration about variation in a contract of employment, and also trying to see the contract of employment and getting information on working practices. This can be done by law. Most employees in this situation will be entitled to a written statement of the main terms and conditions of their employment contract, which, although not actually the contract, is evidence of what is in the contract. If you find yourself in such a situation and you do not have any written evidence of a contract, you can make a note of what was originally agreed between yourself and your employer about the disputed term and when it was agreed. Stay tuned, continue watching. Thank you so much. You can look more about the contracts of employment and how to find out when what is in the contract itself. So when we are trying to consider the options available when dealing with such a problem about a change, such as a change in the terms and conditions, it is important to try to resolve the problem without having to resort to legal remedies. This will be in your own interest as an employee, because there are few legal remedies which would allow somebody in your situation to keep your job. So you should therefore consider the following options in the list, in the order listed. You can accept the change. This should be discussed between you and your employer in light of the limited range of options available, and also possible consequences of trying to take action against the change. Stay tuned, continue watching. So you can write an informal letter to the employer to try to negotiate a compromise, raise a grievance, take some form of legal action. Stay tuned, continue watching. Thank you so much. Stay tuned, continue.
MVC record.
Bravo, Jesus, on the beat.
So let us look at negotiating on pay. If an employee wishing to object to a cut in pay should try to negotiate with the employer. The latter should point out their right not to have an unauthorized reduction made from their wages under the legislation. These will strengthen their position and protect them if they are subsequently dismissed. If the client's cut in pay is due to the employer reducing the number of hours they can work, the latter should say that the client is ready and available to work the full hours. Stay tuned, continue watching. Let us also look at legal remedies and pay. It will usually be in the best interest of the client to negotiate first before starting legal proceeding. It is always important to act reasonably, and particularly if it is later necessary to bring a claim for unfair dismissal. The possible legal remedies for a cut in pay would include situations including making a claim to an employment tribunal for an unauthorized deduction from wages, which could result in the original wage being restored, or sue for damages in the county court, or leave the job and claim constructive unfair dismissal at an employment tribunal, or if you are in a situation where you have left work and you can claim breach of contract at an employment tribunal, or claim discrimination. So let us look at claiming an unauthorized deduction from wages at an employment tribunal. How to do that. Thank you so much. Stay tuned, continue watching. Subscribe to this channel if you haven't subscribed already. And if you watch this video, share with family and friends. And thank you so much everyone who have already subscribed, who have been supporting this channel. We are talking about work in the United Kingdom, specifically employment contract and other disputes associated arising as a breach of this contract between an employer and an employee here in the United Kingdom. So if you are in the UK or abroad, you can consider a situation in the United Kingdom comparing the same with what happened in your country. If you work, if you don't work, because it is important to have this knowledge, because work is a primary source of income. Income is fundamental in our livelihood in terms of economic benefits in a country, or benefit related to income generated facility. If that is correct, stay tuned, continue watching. So let us look at claiming an unauthorized deduction, where an employer has reduced a client's pay, an employee's pay without an employee agreeing, and there is no clause in the contract allowing for this. So the employee may be able to make a claim to an employment tribunal, arguing that the employer has made an unauthorized deduction from their wages. Stay tuned, continue watching. So the claim for unlawful deduction from wages can be made irrespective of how long the employee has worked for the employer and how many hours they have worked. So the time limit for making a claim is 3 months minus 1 day from the date of the unauthorized payment. Stay tuned, continue watching. So in terms of unauthorized deduction, or at least in a situation where the last of a series of unauthorized deduction has occurred, these rules, this condition applies. If there is been a serious reduction, the gap between each deduction must be less than 3 months. This means that there where an employer is continuing to underpay an employee from week to week or month to month, they will always be within the time limit. If the worker is an employee, they should raise a grievance before making a claim for an unlawful deduction from wages to an employment tribunal. If the employee is outside the time limit, they will have to sue in the county court, looking at grievances or raising grievances in fair detail. So there are other advantages to making a claim for an unauthorized deduction from wages. First, the employee will have some protection. If the employer subsequently dismisses the employee, then they may claim an unfair dismissal irrespective of how long they have worked for the employer, because they were trying to assert a statutory right. Similarly, if the employer attempts some other form of distribution, such as reducing the employee's hours, they may leave the job and claim constructive unfair dismissal. Stay tuned, continue watching. Again, irrespective of how long they have worked for the employer, in another similar situation, also, if the tribunal decide in the employee's favor, it can order full repayment of the underpayments in the last 2 years. This in effect means that the tribunal declares what the employee's proper wage is, and so give the employee some wage protection for the future. Stay tuned, continue watching. Thank you so much. Finally, if an employer cannot counterclaim in an application for unauthorized deduction from wages, looking at unauthorized deduction, so suing for damages in the county court, and you also look at where an employer has reduced an employee's pay without the employee's consent, and there is no variation in term in the contract. This will be a breach of contract, and the employee may be able to sue the employer for damages for breach of contract. Stay tuned, continue watching. So an employee can sue for damages for breach of contract through a court, whether or not they are still working, whether or not they are still working for the employer. So if the employee is no longer working for the employer, they can claim breach of contract at an employment tribunal. Stay tuned, continue watching. So looking at most breach of contract claims, such as non-payment of wages, non-payment of holiday pay, and non-payment of contractual sick pay, or also unlawful deduction from wages claims. So it might be better for an employee to make a claim for an unlawful deduction from wages to an employment tribunal instead of claiming breach of contract. This is because the employer can't counterclaim, and the employee won't have to pay any court costs. So the employee can make a claim for an unlawful deduction from wages to a tribunal, whether or not they are still working for the employer. If the employee took their holiday but wasn't paid for it, they can claim breach of contract. If the employee is claiming holiday pay because at the end of their employment they are owed holiday they accrued but never took, they can claim breach of contract only if both the following applies: if they have a contractual right to a holiday, not just a statutory right, and also their contract specifically allows for pay in lieu of an untaken holiday on termination of employment. So if an employee is claiming holiday pay because they are owed holiday from a previous year, holiday year, they accrued but never took, they can claim breach of contract only if all of the following apply. They have a contractual right to holiday, not just a statutory right. Their contract specifically allows for carryover of untaken holiday from previous years. Stay tuned, continue watching, leave a comment below. Alternatively, if their contract specifically allows for pay in lieu of untaken holiday, alternatively, the employee can bring claims for holiday pay under other legal legislation, including for unlawful deduction from wages or for working time regulation 1998. If the employee wishes to claim unpaid notice or pay in lieu of notice, they will need to make a breach of contract claim rather than a claim for unlawful deduction from wages. They can make an unlawful deduction from wages claim if either of the following applies: if the employee and employer have agreed to the employee being on a garden leave and the employer hasn't paid wages for the garden leave, or the employee has worked the notice period and but hasn't been paid for this. So the claims for non-payment of notice or for pay in lieu of notice when the employee has been dismissed are called wrongful dismissal. Although they can be made to an employment tribunal, the claim should be made to a court if either the claim is for more than the set limit of $25,000, the employee is out of time to claim to a tribunal more about garden leave, notice, and pay in lieu of notice. If the employee has had a reduction in pay because the employer has unilaterally reduced the working hours and there is no variation term allowing for it, this will be a breach of contract. So the employee will have to convince the court that they were able and willing to work the normal hours, but that the employer would not allow it. So it will seldom be to the employee's advantage to sue in the courts rather than make a claim for unauthorized deduction from wages under the Employment Rights Act 1996 at an employment tribunal. This is because in court the employee won't have the protection of being able to claim automatic unfair dismissal for claiming a statutory right, because they won't be able to they won't be claiming a statutory right but claiming damages for breach of contract in court. So the employer may also make a counterclaim, which is not allowed when making a claim to a tribunal for an unauthorized deduction from wages. So it would only be appropriate for an employee to sue for breach of contract in the court rather than go to an employment tribunal for unauthorized deduction from wages where the employee has missed time limits for making a tribunal claim, or the employee wants to claim for matters in addition to wages, for example, loss of the use of a car. Before the employee starts court action, they must consider what it will mean for the future relationship with the employer.
So if the employees are also affected by the court, the employee may want to encourage others to join them in the complaint, if this may mean that they feel less vulnerable. So if the employer's response to a threat of court action is to dismiss the employee, they will need to have worked for the employer for the qualifying period to be able to claim unfair dismissal. So the special rule that allows an employee to claim automatic unfair dismissal for claiming a statutory right does not apply to breach of contract actions in the court. Although an employee may not want to take court action, it will be worthwhile pointing out to the employer during negotiations that there has been a breach of contract and that it is possible for the employee to take court action if they need to. Let's look more about suing an employer for wages owed and also claiming constructive unfair dismissal. To make a claim of constructive unfair dismissal, the employee must resign from their job. This should therefore only be considered as a last resort. To be eligible to claim constructive unfair dismissal at an employment tribunal, an employee must normally have worked for the employer for the qualifying period. We talked about qualifying period in the previous videos. If an employee in this situation, the one who wishes to claim constructive dismissal has to show that the employer has breached such a fundamental term of the contract or employment that the employee is entitled to regard the contract as being at an end. Usually, a cut in pay or change in hours is regarded as such a fundamental term, provided that there is not a variation term in the contract allowing for this. However, it can be a matter of degree. For example, a £5 a week pay cut would probably be a fundamental breach for someone earning £100 a week, but probably will not be for someone earning £500 a week. To make a successful claim of constructive dismissal, an employee also has to show that they did not accept the breach of contract. The easiest way of demonstrating this is for the employee to leave the job and to put in writing to the employer the reason for leaving. It is possible to stay working in the job under protest and to later resign and claim constructive dismissal, but the longer the employee waits before they resign, the greater the risk they run of a tribunal deciding that they had accepted the change. A constructive dismissal is not automatically an unfair dismissal. The dismissal would have to be shown to be unfair under the normal rules for unfair dismissal. So the employee who has had a cut in pay should be advised to make a claim to an employment tribunal for unauthorized deduction from wages rather than resign and claim constructive dismissal. If the employer then seeks retaliatory actions against the employee by dismissing them, the employee can then claim unfair dismissal. So they will not need to meet the normal length of service qualifying condition, because they will be claiming that the dismissal was because they were claiming a statutory right. More about claiming constructive unfair dismissal. Thank you so much. Stay tuned. Continue watching. We are going to stop here and continue later on claiming breach of contract at an employment tribunal. Stay tuned, continue watching.
So thank you so much for watching today. Today we have been talking about work in the United Kingdom, and we have also been looking at employment contract, particularly having taken a break from talking about work in the United Kingdom. If you watch this video, watch the rest of the videos about the same topic, because what happens in the United Kingdom happens across the globe. And we are talking about work, which is a primary source of income in the United Kingdom. And this situation, state of affairs, is similar to different other countries, including in Africa and other parts of the world. So stay tuned next time, and we're meeting to continue with the discussion about work, about employment contract without claims. I mean, we will talk about claims arising from legal right of an employee in a relationship between employee and an employer. And this is a very interesting topic across the globe. It is ancient and modern. It started years ago in terms of how the law operates to protect work, and also industry. We talked of development, we talk of progress, we talk of culture, and this is the interplay between development and culture, where there is trust based on culture and also respect for humanity. There is also respecting of the law in terms of development infrastructure, as is found in the legal system of the United Kingdom, but also across the globe, as in the sense involving the rule of law. And therefore, stay tuned, enjoy the video, share with family and friends. Also watch the rest of the videos. If you haven't subscribed before, subscribe to this YouTube channel, support it, click notification bell and clicking like, so that you continue supporting. Leave a comment below, let me know what you think. I will meet you next time we meet, as we always do. And thank you so much for attending today. Thank you. Bye bye.
MVC record.
Bravo, Jesus, on the beat.
Matema, mira what we are, so better como wa. Mira what we are, when get it, carme chanchoa. Mira what we are, so better como wa ya. Mira what we are, get it, carme tuya. Mira what we are, so better como wa ya.